Hello, my name is John Mayer, and I'm the Executive Director of CALI, the Center for Computer Assisted Legal Instruction. The video you are about to watch is from the annual CALI conference held at the University of Michigan School of Law in Ann Arbor, Michigan on June 4th and 5th, 2026. Most U.S. law schools are members of CALI. CALI publishes over 1,400 interactive tutorials that teach the law to law students. Faculty can also use LessonLink to create formative assessments using CALI lessons. CALI publishes casebooks by paying law faculty to write and review books that can be adopted in many courses in law school. These books are free to download from our website, or print versions can be purchased at near cost. You can download the PDFs or even the Microsoft Word versions of most of our books and add your own commentary before distributing to your students. $300 casebooks are a thing of the past, and adopting one book from CALI saves you more than your entire institutional membership. If you would like to learn more, email me at jmayer@cali.org. I would be happy to visit or zoom into your school to talk about CALI.
Okay, what I think is what really interests me is actually the shared assumption that behind all those different responses and themes, and that is, it seems to me there's kind of a common response, which is if we are able to verify the results, verify the cases, then that is sufficient. That is no problem. But I wanted to ask and challenge, and what exactly the output are we talking about here? It is really just the individual cases that we have found, using Gen AI or not. So this is where I'm trying to kind of trying to think about, going back to think about that, how technologies had changed the way that we do legal research. And has it always been the case that the technologies, including today's world using Gen AI, has produced the same type of output that verification of case citation will be sufficient. So in the next few slides, we're gonna, if you don't mind, I'm gonna walk you back to like 1980s or 1970s, and then we'll look from there up into the more foreseeable future. And just to summarize, to me is that during the print time period, if you guys have that experience using paper digest, what is that, the so-called the output, the object at that time is actually the kind of the cases are being classified under a particular topic. Whereas when we get into the digital search time, it is actually not individual cases, it's actually the rank of the corpus of the cases. And then in the early machine learning time, what is coming is actually the relationship behind a relationship and mapping. I'm going to use rival as example. And we're in the current stage, Gen AI, which I want to argue, it is not really the individual cases that Gen AI is generating. It is the synthesized propositions. And then I do hope that, this is to prepare for a paper, so I don't want my paper to be out of date tomorrow. So I decided that I'm going to go a little bit further beyond what is currently happening. So I'm going to talk a little bit about as agentic AI is going to become more and more common in a few months, what type of output it is really producing, and what is that validation task. And for a long time, I feel like quantum computing is so far away from us. But more recently, I got persuaded that it may not be that far. So I'm going to make some speculations about, in a few years, if quantum computing is really being used in legal AI, what type of object output it will be produced, and what type of validation task is supposed to be. OK, so I figure it might be easy just walk through a same legal hypo, so then to see what the attorneys would do and what the attorneys can do during different stages technology advances. So we're going to look at the same research hypo. Does a social media platform own a duty of care to a minor harmed by recommended content? And if we kind of stay out of the current time period and just thinking about for the entire historical revolution, whether you are in 1980s or you're in 2030s, it's likely that what the attorney wants to know is the same. So the legal question is the same. You always want to know what is the controlling law, how have courts interpreted or applied it? Is there really a viable claim for the client? What claims will serve the best interest of the client? Those questions never change. The technology or the technology medium and tools does change. More importantly, the output, or at least the nature of the output, when human researchers leveraging those technologies has changed. And what I want to argue is that because the object changed, the actual validation task actually change as well. So I don't know how many of you have used Paper Digest. But when I first started, my first law library job is actually at Michigan, and that was 2009. And I still remember that for the first couple of years, we have public patron or local attorneys come in, and they still use those Paper Digest. And what is Paper Digest? It is really just a digest, like abstract of cases are classified into different topics. So with that legal question, if attorney at that time opened the Paper Digest, what they can do is looking for a topics that are likely to have, they think that, looking for a topic that has already been classified, and then trying to find cases under that topic. So one thing that I didn't really think about it until more recently was the Gen AI. I started realizing even back then, as a human researchers, somebody else has made some judgment call that you are kind of bound to it. So imagine that using the Paper Digest, there's already the topics being indexed. You don't have a lot of options to stay out of those topics. And you can try to look up a particular topic, and you're gonna find a list of cases with some excerpts, but the human editors has already made a judgment for you. They tell you that that case belongs to this topic, and you can choose from those topics. However, what is the thing that you really find using the Paper Digest at that point? At that point, it is the cases, individual cases that is classified under this particular topic. And at that point, as an attorney, what you need to do is to validate that the cases you're finding is right on point. It is the right topical classification, and you do need to use, at that time, it will be paper shepherds to make sure it is still good law. So at this particular moment, validation task is aligned with the object, which is you are validating the cases because the object is the case. However, as soon as we get into the digital research time, we'll notice that at this point, you suddenly have a lot more options. There could be 143 cases, depending on what terms and connectors you're using, what natural language search you're using. The problem becomes there may be this controlling cases, but depending on the algorithm and the way that database is designed to ensure recall or precision, the controlling cases you're looking for is actually could be buried in the list. Now, at this point also, this time is not human, or maybe human engineering plus the system design has made some judgment call that is kind of out of your control as a researcher, which is the system came up with this list of cases and telling you that those are the cases are relevant to the questions or to the terms and connectors of keywords you're searching. So this is where I realize that the object is not just the individual cases. It's actually that ranked corpus, ranked list of documents that as an attorney, you're supposed to validate, not necessarily just one or two individual cases. You're supposed to validate and look at, for example, is the search database actually giving me a complete list of the cases? Are there any omitted authorities that I'm missing? And then you also need to think about what is the algorithm behind the database? How is that relevant? And this is, I don't know how many of you have read articles from Susan Nevlin, Mark, and also Paul Callister. This is, I think that's pre-COVID. There was a lot of literature that talk about Lexis and Weslow's algorithm and then it's kind of reverse engineering to kind of figure out what their algorithm is. And just more recently, I have had attended a presentation that we still have quite a few librarians looking into comparing the Lexis and Westlaw scope of cases. So those are actually the validation tasks that we're supposed to do when it was that kind of traditional digital research time. And this is a very short time period. I actually personally think this is the golden time period. This is right before Gen AI started. There is about 10 years to 15 years where there are actually a lot of machine learning techniques are being leveraged to make the commercial databases such as like Westlaw or Revel more advanced. And by machine learning techniques, I'm talking about the techniques that is not generative AI. It is more the kind of the classic, say, natural language processing, name entity recognition, or topical modeling. And this is the time period where those techniques are being used. So we're not just seeing individual cases. We're not just seeing a list of kind of the vertical list of a corpus of cases. We're starting to seeing expanded networks or relationship among different cases. For example, for our research hub, this is a time that Rai will be able to present a relationship where you can see cases on platform design and product liability, and they're clustered together or connected together, maybe based on different legal issues like foreseeable harm, system design, effective design, etc. And at this point, the system continues to make judgment for us. It is not something that, again, this is not something that human researchers have any direct control of. What the system does is by representing that network relationship, they're telling us those authorities are actually related to each other. Some of the connections are more straightforward. For example, you may click on a particular case that is being cited. Sometimes the connections are kind of leaning towards more semantic, so it's not that particular straightforward. And the actual validation task at that point is actually, again, not just look at whether those cases are relevant or whether those cases are actual good law. What we're supposed to validate is that relationship. Whether those are actually the connections based on doctrinal or legal theories, whether those are just statistical correlations or there's actually legal significance, and whether you can actually use it for, let's say, analogical reasoning or drawing distinction or inductive or deductive reasoning, and eventually how is that working with the entire presidential building links. And this is also something that if I didn't think about what's happening now, I did not realize that is actually the validation task that we're supposed to do and probably we're supposed to teach our students. And we're right now in this Gen AI time period. And this is where, if you put in a question directly into a chatbot, whether it's Westlaw's co-counsel, Harvey, or just OpenAI Cloud, the system unlikely just to give you a couple of cases. The system going to answer that question. It's very likely they're going to give you a paragraph, and that paragraph is what I call synthesized proposition. So they'll pull a few citations together, but what they're trying to do is trying to make at least appearing to be coherent and justified judgment call or argument, and that's what I trying to. This is the center of my. I'm a part of the center of my thesis, which is that is the output. It is not individual citations. Therefore, the validation task is not just to verify individual cases. It is really, besides verifying the underlying authorities, it is to determine whether that thesis itself is coherent based on maybe authentic cases. And also, we need to also look at whether there's any omitted and conflicting authorities. So more intuitive thinking about this is, let's say if I put a question into the chatbot, AI gave me this conclusion and gave me 6 citations. Even after I verify all 6 citations are correct, that is just the beginning of the job. there should be so many other steps that we need to do to make sure that synthesis is justified. So and this is what I think the court is not doing or requiring the attorneys to do at this point. Just moving ahead a little bit, I really think that agentic AI is already here, and it will become a common thing at the end of this year or early next year. So let's say if we start using agentic AI, and one example would be Codex. If you're using Codex Cloud Code, what the agent is doing is not even to just give you a synthesized conclusion. What AI is doing is actually start the beginning of the research. So basically the agent is, if you delegate that work, the agent is developing the research strategies, or do all the research searches, and then eventually will draft a memo. And this is where system gets even powerful, because basically after you delegate work, the system decided how the research should be done. And the output that we're receiving is actually delegated workflow. And in that sense, it is not individual cases, a list of cases. It is not a related connection or relationship map. It is also not just a synthesized propositions. It is the entire workflow. So once we get to that stage, I think the validation task is actually to validate the entire workflow. We need to make sure the process is reliable. We need to make sure the inquiry is complete. And we also need to make sure the process is auditable. So then it can be reproduced, or at least it can be accountable. And if we're thinking, and this is a little bit speculation, I have to say, based on very limited knowledge about quantum computing, I think it's not just about, we're going to get the extreme size of the computing power. I think what the quantum computing will be able to do in the near future is really revealing a lot of the interactions that is not being reviewed by the current Gen AI or agentic AI techniques. And it will give us a lot of the different spaces of legal possibilities. There will be trade-off and strategic pathways. So what the system at that point will do, if we rely on quantum computing, is the system will actually tell you, here are the 3 different ways you should do this address this legal question. So, and then if my theory is right, which I think is right, then the validation task is to validate the recommendation, and that goes a lot beyond verifying individual cases. So, and what I'm trying to say is that the objects are totally different, and it's well beyond individual cases, and it's pretty much start from the digital research time period. However, the actual task that we can see from what the judicial opinions is still within that document validation time period. And that is the problem that I think we have a huge gap in validation, and that needs to be resolved. So I was trying to understand why this gap exists. I mean, the first thing conceptually come to my mind is related to the current legal rules and governance, because that's how attorneys, expected to follow the legal practice. So a couple of examples will be the Rule 11 sanctions, federal civil procedure, and that's where a lot of sanction cases goes to if you litigate from the federal courts, and there will be similar rules in the state courts. But if you read the text of the rule never says you should just key cite or shepherd. Only you need to do is verify citation. The actual wording of the rule is warranted by existing law. So rule is broad enough, except that the current interpretation somehow is still quite narrow. Same thing with the, I put a model rule, but rules of professional responsibility. 1.1 is one that people talk a lot about. It is about competent representation, but what is competent representation? It is not just about site checking. It is more than that. However, somehow, if you look at the cases, you look at the guidance materials, it seems that at this point, everybody still assume that individual union of the object is still the classified cases. And as a result, you should only verify the sources, making sure authority is correct. What it seems that the entire legal profession has forgotten is that we are already in the Gen AI's time. What Gen AI produces is not individual cases. So if you relied on AI to do, your validation task is supposed to be a lot broader than just verifying cases. So that's just the conceptual work when I was reading the legal languages. I'm trying to find some empirical data observation to kind of support what I'm just said. So we started two different data sets. The first data set we started is actually data set 2. Around last year, we started with 102 cases and expanded to 193. And the reason we used the keyword searches and constructed the case corpus in Westlaw. The reason we did not rely on the open source French researchers database is because I wasn't sure if there's selection bias or the sample is random enough or representative enough from that open source data. So I just decided we're going to go with Lexis or Westlaw. This way we can get capture the cases from different courts and different levels. So the data is still being kind of coded and being verified. Everything on the slides is preliminary. But some of the trends, it seems to be clear. Maybe 60% may not be the accurate once I finish finalizing the coding, but the trend is very clear. What we're seeing is that when court look at those cases, there's 60% of judges doesn't even mention anything about what caused hallucination or the misuse of cases. There are purely no technical analysis at all. And we do start seeing some of the technical analysis about, possibly like, things like, how AI may hallucinate cases. And the good thing is like we also see about 10% where it goes beyond hallucination. They start explaining how LM models works. And it's designed, it's kind of designed based on statistical probability. It is not really designed in a way that is aligned with legal reasoning or is supposed to identify all the nuances. However, I didn't see any cases that kind of extend that discussion into how they actually ruled on those cases. So that is the that data set, that is the current status of our data set. There's a limitation, which is eventually we're going to have to extend it to the 2026 and see if there's any changes with the data set, because right now it's only from 23 to 25. And then when I started that data set, Westlaw did not have a lot of cases that is kind of classified under key numbers that is related to artificial intelligence. But just in order to prepare for this presentation, I actually looked at the key number system and I noticed that there's actually not quite a few key numbers that is on artificial intelligence. I picked 2 of them. There are about 46 cases in the category of attorney misconduct, and that covers up until pretty recently, 2026. What is interesting is actually most of the cases still talking about Rule 11 or the model, but I started seeing cases actually talking about the PR rules 5.1 or 0.3, and those are the human supervisions. It's like supervising, say, junior attorneys, supervising paralegals, supervising non-lawyers. And I haven't finished reading all the cases, but I think it may have something to do with agentic AI, or it may just, the people being supervised are the ones who did the research and then generate some hallucinated citations. However, what is still very alarming is that nobody really talk about the type of behavior that is related to lack of verifying or validating synthesis propositions. Pretty much majority of the misconduct is about citation failures, misquotes, or either the case doesn't exist or the case is out of date. So this is consistent with what I've seen conceptually. And my question then becomes, what would be a framework for validation. I hope that for now I established enough that because the different objects are different, different outputs are different, we do need different forms of validation. Then what is that kind of framework would allow us to embrace the technology while at the same time provide a sufficient validation. And I came up with this framework called technologically calibrated validation framework. I'm gonna stop, pause right here, just in case anybody has any questions. Oh, Shay, I'm going this way.
I had a question on your previous slide, where you said there was 0%, I think it was the previous one, with the sharks, 0% synthesis only sanctions. Does that mean that like the only AI issue discovered was synthesis? Because then my other question is, what would the percentage be where they found like there was a synthesis issue and there was a hallucinated citation, you know, as opposed to like we just found these bad citations?
Yeah, what I meant is that there's not really a lot of discussions about synthesis. Like, it doesn't look at the, okay, you didn't have a case citation, but this whole all the citations put together is not coherent. Yeah, that's yes.
Okay.
Yeah. Do you have a question?
Yeah. For data set two, have you started to, I guess, research the background of these judges who are actually giving tech analysis?
Oh, you mean the people who may have the STEM background?
Yeah.
That's a great question. No, we haven't.
I just thought that may be maybe a reason why they're giving the work.
Yes, yeah. I didn't put all the things on this data set. There's another category about sentiment analysis where we're looking at the attitude of the judges, and that background will be a really good, it probably explains a lot of the differences there. Yeah. Yes.
So two things. First, briefly, I'm concerned. So I appreciate the attention that some people give to the mechanism behind the lens, but it strikes me as potentially problematic to say something like, well, these are ultimately statistical models, and for that reason, we have to think of them as fundamentally, new alien thing, because that is not how human beings work. When I think that I think that contemporary perspectives on how human language processing works might lean more than we might be comfortable with on statistical analysis happening, obviously, under the hood, not because we've all taken statistics class, but at any rate, more importantly, as far as validate from synthesized propositions is concerned, I'm wondering how isn't this something that we've always had to do? And it's just strange that we have to do it, in these circumstances, but that fundamentally a synthesized proposition is an argument. We've always known how to validate arguments, and a lawyer that who submits a lousy argument, one that is not plausible, there's already an accountability mechanism for that, and the only thing different now seems to be the excuse. So I guess I'm wondering.
Yeah, I thought about that question in a little bit different way. I was thinking like, there could be an argument pushing back saying, but then why do we have to think about a synthesis? How to make sure this is coherent argument? Because let's say we have an attorney who tends to be bad. There's a cost of not producing the best arguments. Of course, if it gets really bad, they could be sued by malpractice. But I think one of the things that I didn't put in here that in my paper I want to argue is actually it may not be the thing that pre-Gen AI that we can leave it for the system to work out, but because the Gen AI is too my assumption is that Gen AI is going to be something that everybody's going to use. In order for us to continue, I think it becomes a fundamental how to say this, it becomes a necessary need to actually validate the syntheses, because that's how Gen AI creates, going back to my creates the output. Yeah, I don't know if that answers your question though. It doesn't seem to be.
Well, I mean, I guess what I'm saying is that you can, I would approach the validation of a synthesized proposition same way I would approach a validation of, a proposition advanced by humans. I mean, synthesized proposition. I know that's not what you mean by synthesized, but, we come up with propositions, and in order to convince other people of them, we give reasons. And the same thing is the case
Yeah.
With any decent language model. And if it gives a good argument and we're competent, we should be able to see that and do whatever further investigation is necessary. If it advances a lousy argument, we should be able to see that. And I guess I'm struggling to do that.
No, I see what you're talking about. I think then it's maybe I wasn't being very clear when I say validate Gen AI produced syntheses. Basically, I'm trying to say that there is a competence requirement for the human attorney to validate it. Like, honestly, if the human attorney's ability to validate it is to how much they can act, it depends on their competence of like developing the argument. Although I do want to, part of the papers anticipating counter argument, I want to say that the competence to create everything from scratch is different from validating the competence of generate synthesized proposition that's pre-Gen AI as a human. That competence level might be different from what you need to validate things. However, in this context, I'm not arguing that the attorney should, through validation, should come up with the best argument. It's probably the same level that they can go with, but there should be a process that should be measured, that they will do processed validation syntheses. So yeah, I think then potential counter arguments like what is that level and stuff, like how would the court really measure it, at what level it is considered competence enough.
I mean, well, I'm sorry, I didn't.
No, I see what your point. Yeah, there's no, that's a great point. I would think about that.
I mean, it seems like there is an answer to that too, and it's inconvenient because it's not something lawyers normal part of the legal curriculum, but it's a study of argument, it's logic.
Yeah.
And there is a way of just characterizing the strength of an argument. If it's a deductive argument, then absolutely you can. If it's an inductive argument, other kinds of argument, well, it's a little fuzzier, but this is a studied thing.
No, I agree with you, and I actually feel like that the point I'm talking about this is like there are two implications. One directly related to this conference is about education and how do we develop competence, and that's where I think I agree with you. There's a way that we can get to the acceptable level. What I want to argue is that unfortunately that level is going to be higher than what we already have. Yes.
Piggybacking off of this discussion a little bit, it seems to me like there might be a bit of a psychological element here for this problem. I think it's useful to flag the phenomena of the synthesis validation. It seems to be useful conversation, but of course it's definitely not unique, right? Anytime we use a secondary source, right, that's generally going to be some sort of synthesis validation. So is it that there's something different about, qualitatively, about working with generative AI syntheses, something where it's harder for people to do that validation, or is there more confusion over what stage attorneys are in when they're working with these tools, or expecting? I've had professors say, "Oh, I thought it just tells you what cases you need, now." And there's a confusion about how the technology works and what your process is in that. So it seems to me that there's a human-computer psychology element here, which is probably kind of way beyond the scope of this, but it seems to be kind of important about some of these outcomes that we're seeing here.
Yes, no, that's a great point. I have to say, as I was writing this paper, I suddenly realized I don't know if it's right or wrong. I mean, I think one of the assumptions and one of the reasons I do this paper and all those will stand is that I do think in the future, Gen AI tools is going to be part of our workflow. And on the other hand, I started to, the more I read about this paper, the more I feel like the future of whether it's education or the practice goes with, the competence level goes to the validation. So as a result, I think, did that go a little bit far away from what you're saying?
I think that's kind of it.
Yeah.
It seems to be just that this opens up sort of a deeper question of sort of like beyond sort of initial step. There might be something more forward about how do people then engage or sort of synthesis validation, and is there something qualitatively different about like AI generated synthesis versus like human generated synthesis? Does it take more work to like figure out, oh, this is off the wrong track, as opposed to like comparing like, I don't know, two treatises like Nimmer and Patchtree on copyright and saying like, well, I think I prefer Patchtree on this one for these reasons. Is there something different about that with AI? I don't know the answer to that.
No, that's a great question. No, that's definitely a great question. Oh, yeah, I'll think about addressing that in my paper, but that's really helpful. Yes.
So I have two questions, and they may actually be diametrically opposed. So by synthesis sanctions or evaluations of synthesis, should judges actually care? I mean, judges care about whether or not an argument is frivolous, and if it is frivolous, then they throw it out, and if it's not frivolous, then they'll consider it on the merits. And I think, I mean, how does synthesis fall into that? And my second question is, aren't document level failures kind of a proximate indicator of synthesis for judges?
Yeah, well, no. Actually, I'll start from the second one, go back to the first one, if I remember the first one. Yes, no, that definitely will be an indicator. But what I'm trying to distinguish is that the judges doesn't, like, there's no way in the opinion, written opinion, to show that they think that's an indicator to the next level. So the only thing some of the judges did mention that is beyond the risk is beyond hallucination because it's not designed in a way that is for legal reasoning. But yeah, and I think can you remind me your first question?
To what extent synthesis may or may not be defined by frivolous arguments versus arguments on merit?
Okay, yeah, that's a great question, and that goes to a little bit level, like what level of synthesis is the level that is the trigger sanctions, or what is the level that we're expecting in the Gen AI time of a further time. Okay, so my original purpose of this article is actually trying to elevate, or at least trying to argue that the whole research is more important than ever. In the past, what I can think is that people wanted the actual outcome. They wanted the written memo. But I think because of the AI, the process becomes more important. The research process itself should become more important to justify the outcome. Now, so that's why I focus on the language warranted by existing law. But I do agree with you. The bottom line is actually lower than that. So I'm trying to elevate that a little bit. But it goes back, I think that goes to similar to that question. I do need to find a way to kind of justify a reasonable level of measurement, whatever that is. Yes.
I'm curious where you think we are now, like as far as generative AI or agentic, because my thought is that we are they are doing some of that agentic workflow stuff. They're just doing it poorly, in my opinion. Like Wessel and Lexis, they're skipping steps. And that if we were building the workflows as librarians or scholars, that we'd be doing it differently. And that then when I go in Claude and build my own little legal research skills, I get better output than Wessel and Lexis because I'm doing a process I know works. And I'm just curious if you have thoughts about that, of where we are.
That is a great competence question. So what should be that competence level in that stage, right? so like if we're all using the same agent, like if you're allowed to build your own agentic AI, I think that's like, building it to the way that whatever that level is, that's a competence training that for the attorneys, right? I could be totally wrong. I haven't experienced like a full scale agentic AI yet. I feel like Codex is very close, but I have not had a like really trained like I just haven't done that myself. I think, yeah. Yes.
It occurs to me that there's a toy model version of what's going on with bias propositions. Very different discipline. I'm thinking of automated theorem provers in math. So our programs, there's actually some interesting work now where I think it involved one of OpenAI's models that the novel results in math. But I'm actually, I want to talk about dumber kinds of software that are capable of creating mathematical proofs. And this is an example of an argument, a deductive argument made by a computer program. And the soundness of the argument is not, at least I would submit, is not in fact in any material way different from the soundness of an argument that would be a proof that would be given by an actual mathematician. The only thing that matters are the merits. And I guess I wonder if considered like analogous cases like that, and if you think that is illuminating at all on this kind of question.
Don't know. I feel like I have to think a little bit further on that. Can I go back to you after this? No, I think that's a great question. I think I get what you're saying. If I stand out of this whole Gen AI as a technology media, what is actually the difference? Like, right? I think that's what. But yeah, if you don't mind, I can. I'm gonna go just. Talk a little bit. I think I already talked about this framework, which is what my central point is that we need to look at what is actually being produced and then come up with the appropriate validation and to that. And I do want to cover a couple of broader implications. First is because this is a Cali conference. It seems that the focus is on instruction. So I feel like I'm trying to argue that my framework would also have a positive guidance on what type of competence that the lawyers should develop. And this is where I found the more I read about this, the more I'm going to the way that I'm almost admitted that the future is that we're going to have to work with AI tools and the competence. Instead of doing this, I think everybody has this experience where is if you have AI start doing this, you feel like at a certain point, depending on the type of questions, that it may save your time doing yourself because of the verification power. However, I think I think in my words exploring, as we design future courses on educating students or educating junior attorneys, it might be starting thinking about whether we should focus on validation competence. Now, I can see an immediate counter-argument is that what that means there's certain type of cognitive skills is going to be erosion or just lost opportunity to develop that. And what I'm trying to work on this part is that I think if the validation competence is designed well, I think that may just be a new type of cognitive skills or the more important cognitive skills that people in the future should develop. So what I'm trying to say, I don't feel like validation itself will per se rob people's opportunity to develop long-term cognitive skills. And the other part I'm going to really quickly talk about is the integrity issues because they represent a different different way we look at this issue. So this is trying to come up with some competence, like if we're going with the validation as the focus of teaching legal research, what are the things that we should start thinking about doing, or at least should start thinking about design our course. And it's, again, I'm trying to strictly align with this validation as an anchor point. So what I can see here is that, pretty much I feel like that is myself, what we have focused on teaching legal research is on the first two, which is making sense because for a long time, digital research is the dominant time period. However, I feel like now I realize that we missed those litigation analytics tools or rival relationship mapping tools. What we're missing at that point is relational reasoning. I don't feel like we miss a lot for that at that time, but that would be something that we can think about. Again, I think what we need to prepare for now and for the very near future is how to teach students to validate syntheses, and then it goes through many of the points that you guys have mentioned, but I use that as kind of the learning outcome and design what is needed. And what I also starting to feel urgent is about automating workflow. So when the Gen AI really start coming in, what is that kind of the competence, what type of experience that we should give our students or the junior attorneys about that part. So I think she mentioned that her own experience of using agentic AI is depending on what the prompts she's putting in. I think that would be part of the kind of the examples to show students what is the right way to ensure the process is correct, ensure the entire workflow is justifiable. Do want to touch on a little bit on the integrity issues, because I think integrity represents a different level of issues, which is not just about, so the validation tells us what things we need to think about. I think as this profession, the integrity tells us what type of values that is the intent that we're supposed to protect. So this is what originally I was thinking that, one argument I want to make is that because of the AI has produced different types of documents, we're not really working on the single primary sources or one type of primary sources. We are actually supposed to work on the different type of the objects. I think we should think about integrity in many different ways, including the process instrumental integrity, including how to verify and ensure the true knowledge, as well as the kind of the independent judgment, the cognitive integrity, as well as a legal profession. Eventually, this is a responsible agency issue, like the judgment, has we responsibly exercise a judgment for the interests of the clients, and if the long term for the society. So. All those go together will inform what the rules supposed to be interpreted. I don't want to, instead of propose that a legal reform, I think the current rules has a lot of room for the judges to interpret it differently based on my validation task arguments and also the professional values, integrity, interest that we're supposed to protect. So that's why I'm arguing that the court really needs to start thinking about, when they look at those cases, even using the existing legal framework, how to interpret them in the way that is assuming that AI and the other forthcoming technologies is gonna play a huge role in our research process, including that I think the human's ability to control a lot of the, make a lot of judgment, control a lot of the process is becoming less and less. So I think that's pretty much it. Yeah, so that's just the entire kind of the paper format of the entire, putting everything together. I don't know if anybody has any comments or something. Yes, Shay?
Okay, so I have a question. This was a great presentation. Thank you so much. I totally agree that the assumption you flagged is important and incorrect one. And I appreciate your point about like, what's wrong with it, that we're focusing on the wrong kind of validation. So my question is, I have a hypothesis that the reason for that sort of courts are just not looking at synthesis because everyone's so focused on the citation question, is that that's kind of the most obvious AI error, that if you have a synthesis error that's in a filing you receive, one, you can't really tell, you can suspect, but you can't really tell the difference really between that and an AI one. If you're opposing counsel, the cost of saying you used AI to do this when you're not positive, like you are with the citation error, are high. And so those kinds of errors get sort of masked or dealt with in other ways. Like, I'm just going to say this is a bad argument. You used AI to, whether or not you used AI to come up with it. So my question is, do you share that hypothesis for why you're seeing this, or do you have others? And if that's the case, how do we expose that this is actually the problem? How do we get people to notice instead of just staying hung up on the citation validation framework?
Yeah, no, I agree with you. I totally agree with you. I forgot to say that. I think the court approach is totally sensible. That's the most immediate thing you can observe and the immediate consequence that you can definitively say, you got the wrong citation, you must have used AI. But what I'm trying to argue is like the court really need to start thinking, maybe it's a little bit selfish, but as a librarian, what I really want to do is elevate the importance of the research process. So maybe, I know it's going to be really difficult, but maybe there should be a higher level of really requiring the coherence of the arguments. So it's almost like, it maybe go back to what you're saying. It is nothing to do with, whether you use AI or not use AI, in the age of the AI, maybe the coherence level should be examined. Yeah, I don't know physically, like feasibly, that it's going to be hard, but yeah. Yes.
It kind of put both y'all presentations together. Have you seen kind of like an uptick or maybe in comments under the model rules concerning AI?
I have not looked at that. That was something I'm actually going to look at when I put the guidance. I was like, oh yeah, maybe I should look at that. Yeah, yes. No, that's a great suggestion. Yeah. Yeah, that's you.
As far as regulatory, I guess as it were, perspective is concerned, I guess I'm just tempted to say the same thing that I was saying, which is that don't we have a way already of thinking about this? And it's the same way in which we might think about validation. So if a synthesized proposition is the AI output name for what a human being previously has done, and we would just call an argument. And a workflow is just the AI output version. Well, I would submit as a hypothesis of what we would just call work for a human employee. And the validation for one being critically evaluating the argument, validation for the other being managing. I guess I wonder, maybe the way to look at it is the operative concept is something like respondeat superior. There is the problem that a bad agentic output represents is negligent supervision.
Yes. So I think that may goes to why I kind of put integrity in the same paper, because what I want to say that even in the age of Gen AI, what the ethical integrity is still the so-called the responsibility or accountability agency is still on the human side. So in other words, a human does have an obligation to really, if you rely on AI, human does have an obligation to really validate that workflow, because you are still the one that claimed for that work. You're the one being held accountable. So that may, if I think about how do I answer that question, that might be the way I go with. I'm not saying that's the good answer, but I'm just trying to think, that may be the way that I would go with. Yes.
Thank you so much for the presentation. This was really interesting. I guess I'm thinking about in social science qualitative analysis, and you're asking multiple researchers to have codes and take a look at some results and say, like, can we all arrive at a similar enough conclusion to say that we're looking at the same thing?
Yeah.
And the reason I bring that up is because I note that one element of AI seems what is the AI agent pulling from for sources? So if we're taking a look at human-led research processes, we're asking human researchers to be able to show their work.
Yeah.
And we're asking human researchers to have reproducible results with the same data set.
Yeah.
I'm a little curious if you have any thoughts about the ability of generative AI to show its own work. As far as, like, if we're expecting humans to be able to validate AI, is the AI too black boxed to allow this within whatever system it's working? Because if we're asking to see, like, the underlying mechanism by which the AI is, like, working, then there's a lot of companies that don't want to do that.
Yeah.
And so I'm curious if you see any sort of, like, difficulty in teaching how to do this process when they may run into issues because the AI agent doesn't want to show its work or can't. It might be too complicated.
No,
I'm trying to, like, take a bunch of, like, weird ideas.
No, I know what you're talking about, and I have to say that it is still the biggest issue is, when you do kind of this social science or scientific research, like one of the biggest issues, you can't just rely on AI to come up with things because AI is not really reproducible. Like, I think I may be wrong, but others may have more experience using AI. I think AI is still at a stage, depending on what you put in, even if you put the same prompt, the answer today might be different from tomorrow, and it's still not really explainable. As far as I know, I don't know, but I know there's a lot of people working on explainable AI issues. However, if the question is, if the AI is not explainable, how do humans validate the results? I think that's a really good point, because I think there might be a different argument for that, which is that goes to there is a golden standard, if I can say that, even if the AI may not be precisely explainable or reproducible, there is a golden standard of what levels of coherence argument is supposed to be. So with it's more like you put a human in the loop, and then maybe my argument should be that what you require is eventually you are matching that there's a golden standard that can measure your human plus AI work. I don't know if that makes sense or not. Okay, it's Friday afternoon at 3:30. I'll let you go. Thank you so much, everyone. This is super helpful.